Hello, my name is Edwin Palmer. I'm a member of Burns White, and I primarily practice in the transportation, occupational safety, and health groups. We're going to talk about some of the reporting requirements of COVID-19 as an occupational illness under the Osha regulations. Under Osha regulations, employers are required to report and record work-related injuries and occupational illnesses. As I'm sure many of you are aware, Osha has determined that COVID-19 can be considered an occupational illness in certain circumstances. Today, we're going to briefly discuss when and how an employer needs to record and report COVID-19. To start our discussion, it's helpful to define a couple of terms. When we discuss recording an injury or an illness, we're talking about the requirement that most employers have to record work-related injuries and illnesses on the OSHA 300 logs. Your smaller employers, those employers with less than 10 employees, and certain low-hazard injuries do not have to record injuries, and they are considered to be partially exempt employers. These small employers, the partially exempt, still have to report certain types of illnesses and injuries, including COVID-19. Because of the nature of COVID and because it's impossible to know whether and how serious a particular COVID-19 infection will become, even employers who are exempt from the OSHA recording obligations, it's still recommended that you conduct and document a work-relatedness assessment in case the COVID-19 case develops into something that is reportable to OSHA. All cases where an employee is diagnosed with COVID-19, and that means they have a lab test confirming the diagnosis of COVID-19, reportability requirements, including it results in death, days away from work, restricted or modified work duties, medical treatment beyond first aid, or loss of consciousness. Even if you have an employee who may test asymptomatic, but for obvious reasons they still need to quarantine if they're able to work from home and do their job from home, that may, in a lot of circumstances, still be considered to be modified work duties. Now, what must be reported to OSHA is any COVID illness that results in the death of an employee or any hospitalization that results from a workplace exposure. With respect to the death of an employee, you have to report the death to OSHA within 8 hours of the death occurring, and that's for any death that occurs within 30 days of the workplace event, the exposure at work. With respect to hospitalizations, you have to report that within 24 hours of the hospitalization, and that has to be for a hospitalization that occurs within 24 hours of the workplace event. How do I, as an employer, determine if my employee's COVID illness is work-related? OSHA requires that employers make reasonable efforts based on evidence to determine whether the worker contracted the illness on the job. And OSHA's guidance on this, to determine whether an employer has made a reasonable determination of work-relatedness, OSHA will consider the reasonableness of the investigation, what objective evidence and what evidence exists that the COVID-19 infection was contracted at work. In most cases for an employer, it should be sufficient to inquire whether the employee believes he or she contracted the illness. Probably need to have some discussion with them while respecting the privacy. You still need to discuss any work activities, any non-work activities that may have led to an exposure or infection. Obviously, you need to assess the employee's potential workplace exposures. You're not required to do an extensive medical inquiry. Rather, the decision just needs to be reasonably available to you as the employer at the time that you're making the decision on work-relatedness. And OSHA does note that you do need to give due weight to any evidence of causation provided by the employee, any medical providers, medical records, and the public health authorities. OSHA has published guidance on determining work-relatedness, and in that guidance document, OSHA discusses some of the types of evidence that can support a finding of work-relatedness. For example, if you have several workers who work closely together and who contract COVID, and there's no alternative explanation, that would suggest that the infection is work-related. Similarly, if you have an employee whose job requires them to have close exposure to a customer or a coworker with COVID-19, or their job involves frequent, regular, close contact with members of the public, and again, there's no alternative explanation, that can also weigh in favor of a determination of work-relatedness. OSHA also identifies some circumstances where the evidence would weigh against a determination of work-relatedness. For example, if there's only one worker in the workplace contracts COVID-19 and their job duties don't involve contact with the public, that would probably weigh against work-relatedness. If the employee who contracted COVID-19 had close contact outside the workplace, that would weigh against work-relatedness as well. So those are some of the factors and considerations that OSHA wants employers to weigh when making a work-relatedness determination. I mean, the key term, though, is no alternative explanation. If there's an alternative explanation, you can be justified. There's basis for finding that it's not work-related. So particularly if you're in an area where there's a widespread, in that type of circumstance, there's almost always going to be an alternative explanation. Similar, if you have employees who are not sheltering in place, if they're out dining at restaurants, going to the store, taking care of family members. If your employee acknowledges those type of potential interactions, that almost always will justify a conclusion by the employer that or is more likely than not work-related. And then finally, OSHA notes that, if you gather all the evidence, you talk to the employee, you look at the workplace exposure, you consider all their outside exposures, if any, and, after making that good faith investigation, you can't determine whether or not it is work-related, you're fine to go ahead and conclude that it's not reportable or recordable. Finally, no discussion of OSHA regulations would be complete without a discussion of the consequences of failing to report and record a COVID-19 illness. Failure to comply with the reporting and recording requirements can result in significant fines, including there's a Winder nursing home in Georgia was cited and assessed a proposed penalty of $6,506 for the failure to timely report the hospitalization of 6 of its employees after they contracted COVID. In most cases, a failure to report or record an injury is treated by OSHA as an other than serious violation. And those type of violations can have a penalty of up to $7,000. But there are other categories of OSHA violations, including a willful violation and the repeated violation. So if OSHA develops evidence that the employer willfully ignored the injury illness reporting requirement, the employer can be fined as much as $134,937. And if you get a repeat violation, if you're cited for not reporting COVID illness and then you do it again and you don't report it, you can get a repeat violation that also carries that same penalty of nearly $135,000. Reporting an illness does not mean that there was any violation of any OSHA regulations or even that it's conclusively necessarily work-related. It's, injury reporting and recording is its own separate entity. The negative consequences of choosing not to comply with OSHA's record keeping and reporting requirements, outweigh the potential impact of not reporting those injuries. In conclusion, if you have questions about what you should record or what you should report as an employer, certainly feel free to reach out to me or one of the other attorneys in our occupational safety and health group.